Welcome and thank you for joining part 2 of Seyfarth's micro-webinar series, The Legal Landscape of Hospitality, Key Perspectives and Considerations. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Min Vu. Min, you may begin.
Well, good afternoon to those of you on the East Coast, and good morning to those of you attending from the West Coast. My name is Min Vu, and I'm the head of the ADA Title III team here at Seyfarth Shaw, and I'm located in the DC office. I'm pleased to have with me today my colleague Ashley Jenkins, who is also an essential member of the ADA Title III team, who also works with me on many matters involving our hospitality clients, of which we have many. So welcome, and we're going to hop right in here to answer your the 4 burning questions that you have that are on today's agenda. It's only 30 minutes, so we're not going to cover every detail, but we're going to hopefully give you kind of the bottom line that you need to know. So first off, we're going to answer the question of whether you have to provide lowered beds for guests with mobility disabilities. Short answer is yes, but we're going to explain that further. Number 2, what are the risks associated with using self-service kiosks that are not accessible to the blind? Ashley is going to talk to you about those risks, and there are many. Number 3, what is the proper and compliant procedure for handling reservations for accessible rooms? There is definitely a procedure, and we're going to talk to you about kind of all the ways in which you can run into problems with reservations for accessible rooms. And then finally, we're going to tell you, what do you need to know about website accessibility lawsuits? Are they still happening? Like, what's going on? How can you kind of manage that risk and minimize the risk of litigation? So let's hop right to it. Let's talk. Next slide, please. Okay, so in the last 4 years, there have been 36 lawsuits alleging that hotels have beds that are not low enough for people with mobility disabilities. Specifically, these are people who use wheelchairs. And when the bed is, say, higher than 23 inches, they cannot transfer from their wheelchair onto the bed. So there was a lawsuit, well, there were many lawsuits, but in one of the earliest ones, Miyanko versus Ambridge, understandably, Ambridge came back and said, hey, there's no requirement in the 2010 standards for accessible design that even addresses the height of beds. So therefore, we don't have to lower beds. It's not a bad argument, but unfortunately, the Justice Department decided to show up and weigh in. And the Justice Department said, well, actually, there's another requirement under the ADA that's kind of independent of the ADA standards for accessible design. And that is, you have to make reasonable modifications to your normal policies, practices, and procedures when it is necessary for a person with a disability to enjoy the goods, services, and accommodations that you provide. So under this reasonable modification obligation, hotels do have to lower beds when people request it. The courts all went along with this because there are 4 decisions out there refusing to dismiss bed height cases against hotels. Next slide, please. So the other thing that complicates matters is that there's the issue of the space underneath the bed. So some state laws, including California and I think Ohio for sure, and the 2017 ANSI standard, which is an accessibility standard that has been incorporated into many state and local codes, requires space underneath the bed so that a person who needs a lift to get into the bed can actually use the lift, because the base of the lift has to go under the bed, right? So there's like space underneath, and then there's the height, which kind of squeezes in both directions. Our recommendation for beds in mobility accessible rooms is to have an open bed frame with at least 7 inches of clearance underneath, and a top height of the mattress between 21 and 23 inches above the floor. This can be accomplished by replacing your box spring with a bunkie board if you have a box spring. If you have no box spring, I'm not sure what to tell you. You might need like a thinner mattress. But the bottom line is, if somebody says you can either do this upon request, which means you have to keep your bunkie board in the back in the sizes of beds that you have normally at the hotel, or you can choose to just replace, to comply in all of your mobility accessible rooms so that you don't have to deal with these, one-off requests, right? But either way, just know that if somebody calls you up and says, can you lower the bed, or what's the height of the bed, or do you have an accessible bed? This is what they're talking about. Okay, next topic, accessible kiosks. Ashley?
Great. So we've all seen the proliferation of self-service kiosks, especially in the lodging industry. We have seen them to check into a hotel, pay for items at the hotel's convenience store, or even order food and drink at dining locations. The main point we want you to walk away with today is that if you're going to put in a self-service kiosk in your hotel, you must ensure they're accessible, because having an inaccessible kiosk is very high risk. So what does it mean to have an accessible kiosk? It means that the kiosk must be usable by people who are blind. So in order to be usable by people who are blind, the kiosk must have a headphone jack so that users who are blind can hear the information that is visually presented on the screen to sighted users. Further, there must be a physical means for that blind person to interact with the kiosk that is not a touchscreen. So some sort of tactile interface must be provided so that a blind person can independently use the kiosk. Finally, in addition to being accessible to people who are blind, the kiosk should also be accessible by wheelchair users, which means that all operable parts must be at 4 feet high or below. A perfect example of an accessible kiosk would be an ATM. Having an inaccessible kiosk is a very high risk, as there have been a number of lawsuits. One potential alternative solution that seems really good in theory, but hardly ever works in reality, is to have an employee near the kiosk to assist individuals with disabilities who are having trouble using it. The problem with this solution is that you likely install the kiosk in order to not have employees near that area, or to not have many employees in that area. Thus, it's really not a great solution, and inadequate assistance can actually increase your risk exposure. There are 2 cases noted on this slide, and these cases evidence just this. These cases involve lab work facilities where individuals went to have their blood drawn. These companies used kiosks only for patients to check in. Unfortunately, those kiosks were not accessible, and if a blind person needed help with the kiosk, the manner in which they needed to ask for assistance effectively put them at the back of the line, regardless of whether or not they had an appointment. So obviously this was not a good situation, and 2 massive class actions that you see on this slide originated. So the point is, we recommend that if you install kiosks, they should be accessible. Employee assistance is not foolproof. Humans make mistakes. And even in the best of circumstances, say a lawsuit is filed months or years later alleging that no employee assistance was provided, it will be really hard for witnesses to remember what happened. We may not even be able to find the witnesses if they're no longer employed there. It makes it virtually impossible to prove that assistance was provided, thus making the case very hard to defend. Next slide.
Okay, so now we're going to turn to reservations for accessible rooms. Now, there is a lot I can say on this, and I could probably spend easily 15 minutes discussing this topic. The ADA regulations specifically contain requirements for how you handle reservations for accessible rooms. While it's not on this slide, I just want to point out that accessible rooms need to be properly identified in your reservation system so that a person is able to choose the accessible room that they need, specifically unique to their disability. So for example, there are accessible rooms that have features for people with mobility disabilities, like grab bars around the toilet, for example, or an accessible bathing fixture like a roll-in shower or a tub with grab bars or a transfer shower. Those are mobility accessible rooms. And obviously, because they're different variations of bathing fixture, you have to say, this is a king with a mobility accessible king with roll-in shower, or mobility accessible king with tub. And then there's another kind of accessible room, which is a hearing accessible room, which has features for people who are deaf. Okay. Totally different. I mean, people love to lump this concept of, oh, it's an ADA room or it's an accessible room. That doesn't tell you anything, because it could be that could be the room for the blind, the deaf person, as opposed to the person who is in a wheelchair. Completely different needs, right? So hearing accessible rooms typically have 4 features. They have a visible alarm for the main building fire alarm, that thing on the wall that flashes, a visual notification for the door knock or doorbell, a light that lights up when the phone rings, and an outlet within 4 feet of the phone so that people can use their TTY devices. So those are different. So the point is, in your reservation system and whatever you show to the world, you have to make it granular and identify your accessible rooms with this basic information. That is definitely a requirement of the ADA. The other requirement is to ensure that all accessible rooms can be reserved in the same way as non-accessible rooms. In other words, typically people can do it by calling the hotel, doing it online, or calling the main reservations number, right? Well, prior to these regulations, a lot of hotels like to hold back their accessible rooms, thinking they were doing people with disabilities a favor because they're holding them in case they need them. Well, that's not, I mean, while that is a laudable kind of reason for holding them, unfortunately, the Justice Department does not agree. The Justice Department wants people to be able to book accessible rooms at 3 in the morning online, okay? So therefore, all the stuff, all your accessible rooms need to be in the reservation system, shown in the manner that I just explained, with the level of detail that I talked about. And that is one of the issues. That's actually item 3 on this chart here, which is you must put all of your accessible rooms online on the reservation system. You cannot hold them so that people have to call you to find out what accessible rooms might be hiding in the building. That is not okay. All right. So next, very important, reservations for accessible rooms, however they come in, through your main system, through third parties, whatever, they all need to be guaranteed. In other words, if I booked a king mobility accessible room with a roll-in shower, that's what I need to get when I show up, right? It cannot be that it can't be the room with the tub, because while that person might need the room with the roll-in shower and can't bathe in the tub, the point is you must deliver and provide the room that was reserved. Absent, circumstances totally beyond your control, like, some calamity in the room, taking it out for, maintenance, or perhaps an overstay. But what is not a good excuse, for example, is somehow someone made a mistake and put some other person in the room so that the guest with the disability shows up and there's no room for them anymore. Now, the reason I'm really harping on this, folks, is because this is the #1 problem I get. We handle a lot of Department of Justice investigations. And this is what we hear all the time: the complaints about people not getting the accessible rooms they reserved. So please, it's very important. If you take anything away from this webinar, it is to make sure that you review your incoming accessible room reservations in advance in order to block those rooms and assign them to the people who have reserved them. Now, it's not enough, unfortunately, to look the day before or even the day of, which we know is a common practice in the industry. Because by then, you probably have already assigned that room to somebody, and maybe, their stay is going to overlap with the booking that you need to fulfill. Our recommendation is that every day, the front desk, whoever's responsible for assigning rooms, looks at all the incoming accessible room reservations for the next 14 days, and then assign those rooms to the people with a do not block. That way, you know that the room is protected and you're going to be able to deliver the room. Now, I know what you're thinking. Half those people who have booked accessible rooms don't actually need the accessible rooms. They just happen to book them because they were the last ones available, right? I get it. But if you want to be able to, if you actually want to devote this level of attention to it, you could reach out to these individuals and find out, did you really mean to book an accessible room? If they say no, then you can, with their agreement, reassign them, change their booking to a non-accessible room. But if you don't have that conversation, then you have to assume that they booked it for a reason and you must deliver the room that they reserved. Some other issues that we see are hotels basically charging higher rates for accessible rooms as compared to comparable non-accessible rooms. That's obviously not okay. So please be on the lookout for any discrepancies. Let's see. The other two issues that are kind of, I would say, new in the sense that they're not explicitly in the regulations, but the DOJ views these situations as violations, would be to not make accessible rooms redeemable for points or loyalty redemptions, right? So in other words, normally, you're going to make some rooms available, but not all for points. Well, there's got to be an accessible room option in there, and it should be a mobility accessible room, with one of the two bathing fixtures. And then finally, there's the issue of making your accessible rooms bookable through, OTAs, right? So the requirement is that you must make your accessible rooms available to some OTAs. Generally speaking, if you are sending your rooms to booking.com and to Expedia, that's going to cover the waterfront pretty well. But just please be aware that you are required to send them to the OTAs, some OTAs. Okay, back to you, Ashley.
Great, thank you. Next slide. Okay, so this is everyone's favorite topic. But just as kiosks must be accessible to people with disabilities, so must your website. What that means is that your website must be coded in such a way so that people who are blind and use a screen reader have access to the information that is visually presented to sighted users. And people who are deaf and cannot receive audible information, that information is presented to them in a way that they can read it. So what is the standard that you must comply with? Standard is called WCAG 2.1 AA, which was developed by the W3C. It's considered the industry standard, and there is actually a new version, I think it's version 2.2, that was just recently issued. One important thing to note is that the ADA does not state anywhere that websites must be compliant with this guideline. Rather, the ADA mandates that you provide equal access, and thus, in order to provide equal access to information that is on a website, you must be able to ensure that individuals who are blind get the same access to that information as your sighted users. Over the years, there have been tens of thousands of website accessibility lawsuits, and if you're on this webinar, you have probably been victim to one of them. So as you know, they resolve for between $10,000 to maybe $25,000 with some type of an agreement to make accessibility improvements. If you're hit with more than one of those in a year, it adds up to a lot. However, most recently, we've seen one notable exception to this nuisance value settlement, and it's the Alcazar versus Fashion Nova case that is listed on the website, or on the webinar, sorry. This case was just recently in the Northern District of California and involved a class action where the defendant voluntarily agreed to substantially conform their website to WCAG 2.1 AA, agreed to a $5.1 million damages fund, and over $1 million in fees. The settlement is currently pending court approval, and it's fascinating. I'm sure Min will have some insight into it later on today. One issue that is very specific to the hotel industry is that many hotels actually have two websites. One is the brand website and one is the vanity site. In our experience, the vanity site, which is locally controlled, is at a much higher risk because these local operators, they're just not aware of what their legal obligations are, and generally anyone can upload information to the website. So what does it mean to have an accessible website? Well, obviously your websites are ever changing, and it's probably fairly impossible to have everything be fully WCAG compliant. So a recommendation is to ensure that your user journeys that people need to do to access your goods and services are accessible. So on a hotel website, that would be searching for hotels, reading the information about the amenities and policies, reviewing all of the room information, the configurations and prices, completing a booking, and maybe signing up for rewards. So those are very specific to hotels. One thing that's also very specific to hotels that we have seen be a risk is dining and spa information. These informations or these menus are actually generally put on PDFs. And while PDFs can be made to be accessible, the default is for them not to be accessible. So when you have local operators uploading these menus, often as seasons change, they're not accessible and it's a high risk. It's very easy to see these on a website, and it makes it so that plaintiffs can file lawsuits. Another risk is the lack of captioning or audio descriptions on videos. Both of these can be actually easily completed, especially by third parties. You can farm it out. However, not having it makes it a pretty big risk. One thing to note about captioning is that there are a lot of services out there now that will auto-generate your captions for you using AI, and these are generally no good. And it can even increase your risk because it can provide false information. So if you're going to have this done, captioning and audio description should be done by humans. Another thing to point out about your website is that most of you will use vendors to update and operate your website. You should include a requirement that compliance with WCAG 2.1 AA is in all of your contracts. And when you're doing this, make sure that your vendors are not simply relying on automated testing tools to confirm compliance. Automated testing tools are fine, but they only find 30% of issues. Thus, it's perfectly possible to get a perfect automated testing score and still have a completely inaccessible website. And, it's a barometer, right? We use them to see if there's a canary in the coal mine, maybe, right? Like if you have a bad automated testing score, then sure, we should look. When you're talking with your vendors who are updating your website, you want to make sure they're doing more than just automated testing. And they're also not relying on widgets or overlays to solely ensure WCAG conformance. Manual testing, code review needs to be part of their process. Widgets, which I'm sure you've heard about, if not, we can provide more information on that. They cause more accessibility issues on the website than generally your website by itself. So we recommend you stay away from them. And then finally, just because you outsource your website to a vendor and you might want to contract with them to be WCAG conformance, there's still human error on the hotel operator side where you're updating images, you're updating PDFs, you're posting on social media. Whenever you're posting on social media or anywhere else you have an internet presence, you have to make sure that your presence is accessible. Photos, videos, any kind of text is able to be deciphered by people with disabilities. All of these platforms, Instagram, YouTube, Facebook, they have tools on there where you can add alternative text to your images. You can provide captioning for your videos. So keep this in mind whenever you are, updating your social media presence. Next slide.
So since we actually have 6 more minutes, I'm going to talk before we read you the code. I want to go ahead and just kind of elaborate on a couple points and talk to you about 2 other favorite topics: service animals and pool lifts, since we have time. So first off, I just want to say that the Alcazar v. Fashion Nova case, I wouldn't exactly say the defendant voluntarily agreed to the settlement. They only agreed to this very large settlement after the court actually certified a damages class in California, which, well, probably could have resulted in a much bigger number. So again, I mean, this, I think, this particular case is, I wouldn't say it's an outlier. It's just that there aren't that many of them yet. But I suspect that this is kind of a trend because it's the first time we have seen that big of a resolution. Now, do we agree? Do we think that the court should have certified that class? Absolutely not. And we would probably have fought that harder. But it is what it is, and it's out there. And now there's a case on it. So that just kind of underscores kind of the risk factor. So let me talk for a minute about service animals, because this is a topic that actually just kind of came across my desk this morning. All of you on this call probably know that service animals are dogs or mini horses that are individually trained to perform work or tasks for individuals with disabilities, right? So typically it's got to be a dog or a miniature horse, and I'm not joking. And it has to be trained to perform work or tasks. So that differentiates it from an emotional support animal, which is an animal that makes people feel better, but isn't actually doing any work or tasks. So typically in short-term lodging, 30 days or less, you are not required to allow emotional support animals, but you are required to allow service animals to, to be in your facility and to accompany the person with a disability wherever they are allowed to go. So that's the rule. Now, what came across my desk today was a series of apparently test calls that were made to various hotels by a certain person. And here are some of the things that are not, that apparently was reported or said by the hotels, and I'm going to share with you, and I'm going to tell you why they're not okay. So first off, you cannot require a person with a service animal to stay on a pet-only floor. If you have like floors only for pets, you cannot restrict a service animal owner to a pet-only floor. Next, you are not allowed to ask for paperwork for the service animal. Okay. In fact, if they give you paperwork, it's probably bogus and purchased on a website anyway. So it's like there's no point in asking for paperwork. But the point is, you are not allowed to ask for paperwork. If you think that if the situation looks a little sketchy because there's no obvious sign that this person needs this animal, then you are allowed to ask two questions only. Do you need this animal because of a disability? Now, if the person says yes, okay, if they say no, then that's it, we're done. Not a service animal, right? You can charge them the pet fee or whatever. But if they say yes, then you go to question number 2, which is, what work or tasks has this animal been trained to perform? Now, if they identify some work or task, the dog retrieves dropped items, it senses when my blood sugar is spiking, that is a thing, or maybe even it senses my anxiety and then takes action to prevent a panic attack or prevent an epileptic seizure, or it reminds me to take my medicine at a certain time of day. Those are all legitimate tasks, okay? If they actually give you a legitimate work or task, then that's it, you're done. That is a service animal. You need to treat them as such. And they are never to be subjected to any rules about pets. Okay, no pet fees, no pet floors, no pet cleaning. Okay, only if the animal has damaged, if the animal has damaged the room or the property, then you treat it like any other damage. And also, if it's not housebroken, decides to relieve itself in the middle of your lobby, obviously you can ask that the animal be removed, but the person can stay as long as they're not with their animal anymore. Okay, so we are now at the end of time and we have no questions, so I'm going to read the code. Can we have the code slide, please? Great. Okay, so the verification code for CLE is S as in Sam, 1121. I want to thank all of you for attending. Hopefully you found this helpful, and come back and see us for the next micro webinar. Thank you.